Welcome. We are visiting the values of the Constitution of India. Our focus shall be upon the justice systems permissible under the Constitution of India. Justice systems is a concept. Justice systems an institutional apparatus. Justice systems is a system of justice. This system of justice is to be imbibed by its constituents. See, the Constitution of India provides for the substantive laws. It also provides for the procedural laws. It as well provides for the institutional apparatus designated as courts. The courts as well is a big, very complex, very detailed institutional setup. There are judicial officers, there are lawyers, there are court officials, and there is whole chain of policing and administrative components of this system. So let us begin from the very beginning. Let us try to evaluate the structural setup of justice. The Constitution of India is adopted and given to ourselves by we, the people of India. And in the preamble itself, at the outset, we have emphasized, we have ensured that there will be a justice, political, social, and economic. When we classify justice as political, social, and economic, then naturally the poser is whether this classification in itself deserves to be revisited or not. And in this context, let us also pose to ourselves that when we talk of justice as the adjudications in courts, then whether the same gets its demarcation domain within the political justice, social justice, or economic justice, or that this justice as adjudication through courts established under the Constitution of India is of something distinct, generic, values justice, or that the same as well is either a political justice, social justice, or economic justice being visualized and being enshrined in the preamble itself. In this context, when we will come out of the Constitution and when we will place ourselves within the jurisprudential domain, within the philosophical domain, within the conceptual domain, within the ideal visualization, projection of a human mind, then the word justice and the word justice system naturally will have many different generic features attached to it. However, when we talk of and when we confine ourselves and when we restrict ourselves to the justice systems under the Constitution of India, then somehow it gets confined to the justice as adjudication in the courts of law established under the Constitution of India. In this context as well, when we have a deeper insight about this apparatus, even then we are confronted with situations like the judicial powers, then as constitutional courts, as tribunals, as administrative tribunals, as inquiry tribunals, and all that. So, all adjudications ultimately take us to the two adversary parties, two distinct approaches, to different schools of thoughts, to different answers for the same situation. And when the different answers have their advocates, and when these different answers require some acceptable answer, then naturally courts come in, adjudication comes in, justice systems come in. In this week events, and which is alive even today, when we visit the agitation by the farmers, and one of the questions coming to forefront here is as to, in case of contract forming, when there will be a dispute between the contracting parties, of which one will be the farmer and the other will be the corporate, then the imbalance and other realistic features of such disputes, as is being visualized to be in the court of the SDMs, deputy commissioners. So these administrative apparatus for adjudication of such generic disputes, differences, are such which naturally again confront us as to whether these can be called really the courts, whether the procedure can be said to be just, whether it can be said that this pattern, this setup, this visualization, such legal framework, whether it will stand the test of constitutionality or not. When we will be confronted with this type of questions, then naturally we again have to visit the core of the Constitution of India, which features, which values are constituting core of our Constitution. What are the core features of our Constitution, and how these core features will be the touchstone for coming to the conclusion as to the setting up of the courts, like the administrative courts, in case of disputes in respect of the contract forming. Will that be standing the test of the constitutionality or not? Then, in this context, also will be a food thought for each one of us to pose and try to evaluate an answer as to what difference of quality of justice is going to be in such administrative courts with respect to the very substantive civil rights under the contracts, from that what we are dispensing here in the civil courts. The civil courts as such on the one hand, and the administrative courts being visualized under the new enactments in respect of the contract forming, or the two banks of the same river, but whether on both banks of this justice of river, this river justice on its both banks, whether is to provide us the same degree of values. The adjudication as justice naturally has many ingredients, and one of those is the timely dispensation. Secondly, is a fair procedural dispensation, and third is the realistic ingredient aspect. The expediency, the reality, the procedural quality, the manpower, the training, etc., get connected when we have to evaluate whether or not this new visualization of contracts adjudication through administrative setup is desirable. Should it be taken as constitutionally valid setup or not? The disadvantages being set up with respect to the adjudication through civil courts is that its procedure is inherently of the values which delays adjudication. Whether this factor in itself is going to be a sufficient justification to make another setup of courts as has been done in case of the contract forming disputes. Let us have a pause and let us revisit the institutional growth of the judicial courts in our country, starting from the company, East India Company days, reaching up till the Magna Carta 1857, 1861, then sequentially reaching up till Government of India Act 1935, and then under the present Constitution of India itself. Then it will come to forefront as that institutions themselves as well have their sequential growth. If sequential growth of the judicial systems is a factor, then naturally the question is bound to confront us as that how we can suddenly create new setup of judicial courts. We are creating day after day a number of tribunals. These tribunals as such are a reflection upon the mainstream judicial courts setup, whether the regular civil and criminal courts are not potent enough to meet the realistic features of the adjudication domains being vested in different tribunals. Then the arrangement of having a district level subordinate courts of the status of district judges and session judges, and then suddenly having the upper floor of the constitutional courts of the status of High Court and Supreme Court. Isn't it there is a big gap which deserves to be fulfilled? Isn't it there is a necessity to create judicial commissioners court to bridge this gap between the district judges and High Court? These and many other questions are to be faced by us while we shall be appreciating the judicial systems under the Constitution of India. Now, if we are having the judicial commissioners courts to bridge the gap between the district judges and the high courts, then simultaneously another sequence of questions will arise, and we have to meet the same. Likewise, the current deliberations about the creation of the All India Judicial Services as well is already there in the space, and these new institutional apparatus considerations as well are naturally to confront us many questions. Let us have a pause. Let us revisit the core values of the Constitution, and also let us visit the different legislative provisions of List 1, List 2, and List 3 of 7th Schedule of the Constitution of India, as per which there is a distribution of legislative sovereignty, and tabulate as to how the different legislative courts, different adjudicational systems can be legislated under the Constitution of India. At present, the Civil Procedure Court and Criminal Procedure Court provide for different types of courts, different gradations of the courts, including the procedures to be followed by such courts. Then, since 1950 till date, we have a very large number of tribunals, and these tribunals have their own specific characteristic procedural setups. This scenario, this spectrum as well is a very big legal, debatable, arguable domains. Our law schools, law universities, and even our law jurisprudential philosophical writings deserve to attend to this aspect as well, and research deserves to be continued. Much deeper insight is required. We, the lawyers, we, the students of law, we research scholars, we, the exponents of justice delivery systems, and the scholars devoting themselves, the judges exclusively concentrating upon the justice systems, shall have a revisit and come to the conclusion whether the trends of different experiments conducted during these 75 years in respect of the justice systems deserves to be given a particular direction or not, whether or not the entire judicial system deserves to be revisited for ascertaining, like the core values of the Constitution, the core values of the foundations, the systems under the Constitution of India. We shall devote ourselves to this thought as that whether we are imbibing the justice system's values of our Constitution, whether the justice system in its existing state deserves to be revisited or not, and we shall come with our answers to it, and these answers will be of great bliss for us. Thank you very much.
Thank you, sir.